morning.
Good morning, Mr. Cuttle.
Good morning, Your Honor. May it please the Court, William T. Cuttle for the mother in this case.
Now, I'm going to let you know when you have 1 minute left, okay?
No, not right now.
Yeah,
At the point when you do.
when you reach that point.
This is a 7.5-minute argument?
No, this is
15.
15 minutes.
Okay.
Please proceed.
Thank you. Your Honors, in the Commonwealth of Massachusetts, it's the public policy to make all efforts to encourage and strengthen family life for the well-being of children. And that's set forth in General Laws, Chapter 119, Section 1. That did not happen in this case, Your Honors.
Did the mother accept help from the Department of Mental Retardation?
No, she
You
didn't.
represent the mother, correct?
I represent the
Yeah.
mother. In that one particular case, no, she did not, Your Honor.
Okay, she didn't. Did she follow her medications regime faithfully?
In general, she did. She had some difficulty with it.
But she had some difficulty. She didn't
Right.
follow it totally. And also, if family therapy didn't help before, why would it help now?
Well, family therapy wasn't offered to the mother before, Your Honor.
It was never offered.
Not to my knowledge of the record, to the mother and Ilona.
What therapy was she in from 2007 and thereafter? Or maybe even earlier than that,
She was in-
2005, yeah.
She was in individual therapy.
And also, how old is this child now?
I believe she's 13.
Okay, that's what I thought. So if the mother is learning so slowly, which I think everybody admits, how old is the child going to be by the time the mother improves sufficiently? I think the child will probably be an adult.
Well, Your Honor, with all due respect, that's not the focus of care and protection cases and termination cases when...
But this mother, well, we have to look at the facts of this case. This mother is improving even by your most vociferous supporters in testimony. She's improving very slowly, and if she's improving very slowly, we have a 13-year-old child.
Your Honor, she was improving without receiving any services designed to meet her special needs.
Well, that's a
And
point
that's,
of
and that's
argument.
not something that's supposed to happen in these cases. The department has an obligation in these cases to provide reasonable services to parents and children. People who come into the department's care and custody, the parents have shortcomings. That's why they're involved with the department. And the department has to provide services to give the child and the parent an opportunity to have their relationship, which is it's a fundamental right for a parent and a child to be together.
But does that mean forever? Or for a reasonable period of time until it's clear that reunification isn't going to work, at which point the mechanism changes? And isn't that what happened here?
Well, that's a very good question. The department would argue, I believe the case is adoption of Nicole, that once the goal has changed, they can change the focus of their services. But in this case, things never got started on the right track. The department relied, as I stated in my brief, on a parenting evaluation that was found to be fraudulent. And because of that parenting evaluation, they had what is called a permanency planning conference, which is an internal conference that the department has, does not involve counsel for the child or the mother, and they made a determination that the goal should change.
But before that, there were two, one was 16 weeks and one was 12 weeks, two classes that one was nurturing, in which, if I am remembering correctly, the child and the mother participated together for 12 of the 16 weeks or 9 of the 12 weeks, whichever one it was. So they did do that before there was any. I think that occurred before there was this change of focus. Isn't that right?
That's correct. But to point an important fact out regarding that issue, as there was a court clinic evaluator who the judge appointed in February of 2008, I believe, because the first parenting evaluation was.
Right.
That evaluator basically said in her report that the services that the department provided were insufficient. They did not meet her needs. The department should have contacted the Department of Developmental Services to provide services to the mother that could give her a chance to benefit from them. This is a woman who Dr. Castro determined in a cognitive evaluation in the spring of 2007, had significant cognitive impairments. She was operating on a 7-year-old level, and the services that she was provided with weren't helpful. I think commonsensically we all understand why they wouldn't be helpful to someone like that. But the Lenore case says that you cannot terminate a parent's rights just because of a cognitive impairment.
But here, of course, you had a cognitive impairment combined with a criminal conviction for having taken the belt to the child, plus the observations during the course of the visits that the parent was making no meaningful contact or meaningful attempt to communicate with the child. I mean, isn't there, at some point, don't we have to say that the child's interests must come into play, and the fact that she was doing so well with the pre-adoptive home and so poorly when she was with the mother that it's appropriate to say it's time to have the adoption kick in?
Yes, that there is a time to do that. And in these cases, Your Honor, the child's interest is paramount to the parent's interest. I agree with you about that.
So is it not a matter for the judge's discretion to determine whether or not that time has been reached here?
It is, but in this case, it's our argument that the trial judge, who did his best to try to eradicate what had gone on in this case, basically relied on a parenting evaluation that was basically a snapshot of mother and what her limitations were, who had never received the services she was supposed to get, and the department was mandated to provide to her beforehand. And at the very least, what we argue is that mother's unfitness, and as the court is very aware, I didn't argue that at the time of the case there wasn't evidence of mother's unfitness. My argument is that mother's unfitness may have been temporary if she'd been provided the proper services. And in cases like this, the court had other options other than terminating her rights. And the court could have issued a permanent custody order, sent the case back so that the services that mother was never given could be given, so that the trial judge, when making the decision, finally would have evidence to determine whether mother's fitness was permanent, was something that could be changed. And that really would have been in the best interest of her daughter, because with all the shortcomings, the trial court found that there was a strong attachment, there was a bond between the mother and the daughter in this case.
Do you have a problem with the judge's the judge's visitation order?
I do. Can I just ask how much time I have? Because
You have 7 minutes, Mr.
Okay.
Cuttle.
I do have problems with it, and I think that the appeals court properly remanded the matter back to the trial court. I mean, I think it's important to point out that the trial judge didn't have the benefit of the RICO case when he made his decision. And my argument is straightforward. It's not lengthy. I don't think it needs to be in this case. The department and the child's counsel, their arguments focus on the rights of the adoptive parents and whether my client's rights supersede the child's rights. Let me be clear. It's not an issue in this case. Adoptive parents have the same rights as biological parents. My client's interests are secondary to the child's interests here. But in RICO, this court clarified the decision in veto, which basically said that the court has equity powers to make sure that the child's best interests are honored and protected by the court.
May I ask you, if hypothetically adoptive parents said, we don't want to have contact with the biological parents because we want time to develop our own relationship, and we don't want to have that interrupted with periodic contact with the biological parent, what would you say about that?
I'd say that's an issue that should be brought back to the trial court for a hearing to hear all information, including evidence that would be helpful to the child on that position.
And if a judge concluded that it was in the child's best interest not to continue to have contact with the natural parents because the adoptive parents wanted to have time with the child without contact with the natural parents?
I would not agree with that. I think the RICO case points out very clearly, and it's very helpful and important for everyone in the care and protection field to remember, that children have a right in these cases. It's not just the departments, what they're supposed to do. It's not just what a pre-adoptive parent or parents' rights are. It's the children in these cases. And
So even if the pre-adoptive parent said, well, if you require us to do that, we won't be available for adoption, you would say?
I would say that the court would have to strongly consider the child's position on that and would have to make a determination. That happens a lot in these cases, Your Honor. I mean, pre-adoptive parents are identified and are not always able to fulfill their goal to adopt a child. And sometimes, as the Vito case points out, you know, there are issues that have to be considered, not just the best interest in collaboration with the best interests of the child, such as the chilling effect of orders, visitation orders, and how that may affect finding adoptive parents. That's not the case here. In this case, this child was placed with this family the day after, I believe in December of 2008. This isn't a case where she needs contact with her mother because of I think the term is a tortuous path to a pre-adoptive setting. What happened here, and what this court pointed out in RICO, is the court found there was an attachment. The court found the continued contact was in the child's best interest with her mother. And this court pointed out that orders like this that should be put in place, that shall be put in place to honor the protection of the child, they're provisional. And I want to make sure that the court understands that I'm aware of that, the client's aware of that. This case has been going on for 2 years. And neither this court, nor the appeals court, nor the trial court have any idea whether the child's wishes have been honored. And that's because there's not a visitation order in place. And if a visitation order was in place...
Is the child represented by counsel?
Yes.
Have we received any briefs, or have they communicated?
She's arguing today.
Child's counsel will be arguing.
So we'll hear from the child's interest, yes.
The point that I want to raise is that these orders, a visitation order here, which in my view is required, could be reviewed by the trial court, if the department could bring it forward. If this family is going to adopt the child, if the pre-adopted family is still the family, and they have a 210-6, General Laws Chapter 210, Section 6 hearing, as is pointed out in RICO, that judge at the time can review the orders to see whether they're still in the best interest of the child.
I take it the judge could say, I think limited visitation is important for the child, and I'm going to order it for a year. In other words, the judge can impose actually a very limited period of post-termination visitation.
That's correct.
Do you see, I mean, it gets discussed as post-adoption, but wouldn't there be a distinction between a post-termination pre-adoption and post-adoption, just as you're just pointing out? In other words, couldn't you have one order for one period of time, and then it's up to the adoption judge under Section 6 proceeding whether there's going to be continuing visitation after the adoption goes forward?
I believe that could be done. I never thought of it that way, Your Honor, but I think it could be. And in this case, the trial judge said that continued contact was important. He didn't distinguish post-termination from post-adoption contact. But the bottom line is the child has, in my understanding, has not been adopted yet. It's been 2 years, so this would be the post-termination period.
Right.
And in closing, I would just remind the court and ask the court to send the visitation order back down to the trial court so that he can determine whether it's still in the child's best interest to have contact with her mother, and if so, then make a visitation order that can be updated and looked at by the adoption judge, and the parties can come forward if they need to. And with respect to the termination issue, I respectfully ask that the court reverse its decision and send it back to the trial court for a remand. Thank you.
Thank you, Mr. Cuttle.
Good morning. May it please the court, my name is Diana Cowhey and I represent the child in this matter. I will be taking 5 minutes and my brother will be taking 10 minutes. The child's position has been clear and consistent. Since, and if I may just clarify the record, the child was placed in the pre-adoptive home in December 2006, not 2008, as was represented. Also, as to clarify one other matter, the mother was offered family counseling, and that can be found in the child's brief on page 15, and that's in transcript 12, pages 27 and 31. The child's position has been clear and consistent, and it is as follows. The child loves her mother, but she does not wish to return to her custody. She recognizes that since she was 3 years old, she's been the victim of physical abuse. She would like to be adopted by the adoptive parent and family, and the adoptive parent wishes to adopt her. The child would like to maintain contact with her mother, and the foster mother testified that she would encourage that. And in fact, she would allow reasonable visitation. She would also encourage any sort of phone contact. She further testified that she had never limited the child since 2006 to visit with her mother or to prevent any sort of phone contact. The trial judge credited the pre-adoptive mother's testimony when she testified to that. He also found her to be in the best position to decide today and in the future whether this child should see her mother or visit with her mother or talk to her mother, and that she is in the best position to make that determination.
Do you see a difference between the period of time in any case, but obviously you're talking about this case, but in any case between the pre-adoptive and the post-adoptive period of time in terms of an order of a judge on visitation?
I do, to the extent that the purpose of visitation is to help a child transition from one home to the next. So if we are dealing with only a post-termination situation... I understand there are cases that say that's certainly a purpose, but couldn't there be other purposes as well? That is, that the bond itself is going to be important forever? Yes, it is possible that that bond may exist. However, upon termination of the mother's parental rights or any parent's rights, the adoptive parent, if there is one, assume those full constitutional rights. And so if we are dealing with a situation where a adoptive parent is in the picture, then there should be no distinction between post-termination and post...
But what if the adoption doesn't take place? I mean, that happens, right? In other words, there's a pre-adoptive family, and then something happens, and in RICO itself, there was one or more pre-adoptive families that it just didn't pan out.
Yes, that's correct. And in that instance, it was very appropriate to issue the visitation because that child had no one else. In this case, the child has had the adoptive family in her life since 2006. There is no purpose for that. No purpose would be served to mandate visitation. The legislative intent for visitation is not to encourage and develop and nurture a bond that exists. It is to help transition this child. She has already made the transition.
Well, but surely, surely judges have the power to order visitation. I mean, right? I mean,
yes.
They do, even post-adoptive visitation.
Yes.
So, and clearly here, the judge said it's in the best interest of the child. This is all about the best interest of the child. I find it's in the best interest of the child. So why shouldn't we say, well, if it's in the best interest of the child, then you should issue an order which requires it?
For a few reasons. First, the adoptive family is in a better position to determine the extent of visitation and contact. Second, if it is a court-mandated visitation, we are unnecessarily intruding on the adoptive family's right to raise this child. State intervention should be limited to instances justified in only limited instances.
So are you saying if the court issues a specific order saying at least once a month, that's unconstitutional? But if the court issues an order saying it's the best interest of the child that there be visitation, and I'm going to leave it to the adoptive family to decide precisely the parameters, that's okay?
Yes, if I'm understanding Your Honor correctly, in the
So
first...
it's the level of detail on which the constitutional question turns?
Yes, to the extent that if it's court-ordered, then the adoptive family has unnecessarily been brought into the court system. And I think at some point, particularly in this case, the child's rights has to come first, and the adoptive parent is in a better position to determine the extent of visitation. I understand my time is up. There's nothing further.
Thank you.
May it please the Court, Brian Pariser on behalf of the Department of Children and Families.
We haven't distinguished between post-termination and post-adoption, should we?
I believe this Court actually in veto 10 years ago did use those terms. And did.
Right, but I mean, we've sort of said post-termination, post-adoption, visitation. We haven't set out different sort of parameters.
I'm unaware that this Court has, and frequently they do get lumped together. In this case, actually, the Court merely...
It got discussed in RICO, didn't get ordered, but I mean, that there might be a distinction between the two.
Yes, as well as in veto. This Court obviously did not distinguish them, spoke merely of ongoing contact in somewhat general terms. And just to go back to some of the questions raised by the bench, I don't know that the issue in this case of post-termination visit has been raised on appeal. It wasn't particularly ordered. It appears from the order, since discretion is being left to the adoptive parents, and it's a reasonable presumption that an adoptive parent assumes those rights of a parent upon adoption, that the trial court in this case was contemplating really a post-adoption order and leaving it to the discretion of the adoptive parent. Obviously, prior to the finalization of an adoption, the child continues in the custody of the Commonwealth in the Department of Children and Families, and customarily under statute, decisions regarding visitation are left to the department absent an abuse of discretion. Obviously, those matters can be addressed. This Court's spoken in Jeremy and Isaac about how that can be addressed. After a termination of parental rights, the child continues to have counsel and continues to have the ability to address the department's decision-making with the trial court. So there's continuing jurisdiction over the matter.
So in this case, the order, you say, really doesn't require post-termination visitation? Just post-adoption visitation?
It doesn't require anything.
The order makes, the trial court makes a finding that ongoing contact is in the best interest of the child, and makes clear findings that the person who's in the best position to decide the contours of that visitation is the proposed adoptive parent.
But certainly doesn't, even starting from the day of the order, doesn't preclude that person from saying, I don't think it makes sense anymore, and she's not going to see her mother.
That's true. That's not precluded. However, there are mechanisms in place to address that should that happen. The first thing I would bring to the Court's attention is the Court took great pains to make detailed findings that this wasn't the adoptive parent who was going to do that. This is a trial court judge who heard firsthand from the proposed adoptive parent, took her testimony, made, as is his right, findings about her credibility, determined that she has committed to allowing that relationship to continue. There is nothing in the record to indicate in any fashion that that is going to happen in this case. So as a factual matter, as a well-supported finding of fact, that's not a presumption that seems to be reasonable to start from. So we start from the presumption that that visitation is going to continue. Now, if something unforeseeable were to happen up until the time of adoption, clearly, as I said, the child has the opportunity to bring that back to the trial court. Yes?
Oh, no, finish.
So there are those safety mechanisms in place. And obviously, as this court recognized in RICO, ultimately the adoption judge should review this matter before finalizing an adoption.
So what was the appeals court basis for sending this back?
It appears that adoption of RICO has been read to require, by some judges, to require a specific order for post-adoption visitation in every case that the trial judge finds.
Adoption or post-termination?
Well, again, I'm speaking in terms of post-adoption because I believe that's what the court's order appears to reference.
But you were saying RICO's been read by some judges to mean that it wasn't this judge because RICO's decided after this case. So when you say some judges, is it post-adoption or post-termination?
I believe we're largely talking about post-termination. In a situation where there's an adoptive family that's been identified, the child's been there for the statutory period of time, as is the case here, really the post-termination period, absent a lengthy appellate process, should be a fairly short period of time. It's going to move to adoption fairly quickly, assuming everything goes well. And as I said, if we do have a lengthy period of post-termination visitation, the department's really the decision maker in those cases, and there's other case law that covers remedy for any
But
alleged
with
problem.
respect to just on the remedy question, if the person, as would be the case here, who's unhappy, let's just say, is the mother, or unhappier, once her parental rights have been terminated, does she have the right to come into court on visitation?
I don't believe so, Your Honor. But then again, it's very important to note that this court has been very clear in adoption of veto and in adoption of RICO that the right to visitation, the interest that's being protected, is the child's. The parent, the biological parent in this case, has no right to enforce visitation. It's not her visitation with the child. It's the child's interest in that relationship, in whatever source of support she gets from that, with the biological mother.
But isn't that part of the problem here, in that we have a judge's findings which says the child appears to love her mother and wishes to maintain contact with her, and the pre-adoptive family essentially agrees with that, at least to the extent that they wish to maintain contact? Why should the court not essentially order it, and if there are change in circumstances, then the department, or if there's an adoptive family, that family can come forward and say there's been a change in circumstance. It's not what it appeared to be before.
Well, really for two reasons. The first is this court clearly recognized an adoption of veto, and I paraphrase, but essentially this court said that courts are not the best place to manage these affairs over long periods of time. That taken into account with the now adoptive parents' constitutional rights to make these decisions, if you enter an order when it is not absolutely necessary to protect the interests of the child, when there's no evidence that the adoptive family is going to act adverse to the child's interests, what you are doing is you're setting in place an order that will remain in effect for conceivably through the child's 18th birthday, that will constrain the adoptive parents from flexibility absent having to engage in ongoing litigation with the parent who's been deemed to be unfit and whose rights have been terminated. The adoptive parent is the parent. This is the person who makes those decisions. And I just would like to remind this court about its decision in Blix, the U.S. Supreme Court's decision in Troxel. The language from those cases is cited in the department's brief. This court and the U.S. Supreme Court have determined that as a matter of law, a parent will act in the best interests of his or her child. We presume that as a matter of law. The court...
You're also making the point that the adoptive parents become the parents after there is termination.
Oh, after there's adoption.
Yes.
But yes, absolutely. And that is the point that I was making, that adoptive parent should be entitled to the same presumption of acting in the child's best interest as any other parent who has not come into
So
court.
why should this order then not carry on until adoption? I mean, during this phase in which the department is the parent, the order can say contact should be maintained, and upon the adoption of the child, then the parents can decide what's best.
Well, I submit that that would be a very different situation. That obviously isn't what this trial court ordered. I think at that point now we're questioning the court's order running to the department as custodian. And in that situation,
Which was
again,
like RICO. Which was like RICO.
well, it was like RICO. And I'm not disputing that obviously Vito and RICO provide the court with the ability to enter that order. That order, however, runs into questions of the department's authority. It runs into Edgar-type questions of modification. That order is going to be ongoing before the court. It's a very different situation.
It sounds as if you're asking us to reverse or to undo RICO.
The department's argument today is concerning the order as it runs to an adoptive parent.
A pre-adoptive parent.
Or, well, in this case, pre-adoptive parent, but as the court left discretion in that person's authority, I believe it's reasonable to read it as taking effect upon adoption, because prior to adoption, that individual would not have the authority to make that decision. The pre-adoptive parent, before adoption takes place, isn't the decision maker. That's not the custodian.
The decision maker is the department.
Up until adoption, yes.
Right. And we said that in Isaiah. And what's the other case?
Care and protection of Jeremy,
Yes,
and care and protection of
Jeremy and
Isaac.
Isaiah.
That's right. And the
Yes.
department's decision-making is subject to judicial review under the law set out in those courts.
I heard you earlier to say that there should be a distinction between pre-adoptive and adoptive situations. Now I'm hearing you to say that once an adoption is entered, once the adoption occurs, there should be no order for visitation. There can be no order for visitation.
The department would say, and this is written out in the brief, but essentially, this court has said that orders for post-adoption visitation can enter. The department is not disputing that law, is merely saying that when you have a situation where the adoptive parent has shown every indication of honoring that relationship, essentially, Vito gives you a continuum of cases. There are cases like the RICO case where clearly an order was appropriate post-judgment. There was no adoptive family. The relationship was with the biological family. That's clearly appropriate. In situations that this court has looked at in Vito, it was not appropriate, where a primary attachment's with the adoptive family, where that's who the child has transitioned to. That's in the best interest of the child. A post-adoption order is not appropriate. What you have in this case is something in between. And in that case, I would submit that the court needs to look at not only the bond and who the primary bond is. In this case, it was with the adoptive family, the primary bond. The rights of the adoptive family, those constitutional rights that are honored in Vito and in RICO, and the policy of that being the best place, the adoptive parent's judgment being the best place to make those decisions. That weighs in favor, actually, of doing exactly what this trial judge did, deferring to that. This court has in some cases, I believe in the Yeoman's case and in the ENO case, has in some cases entered orders with regard to a fit adoptive parent and visitation with a third party. But it's important to note that those have only been in cases where there is some evidence that the fit parent is actually going to interfere with that important relationship. Okay? And I would submit, the department would submit that essentially, if there is no evidence that the adoptive parent is going to interfere with that relationship, even when it's been found to be important, and there's every evidence that they're going to honor it, as in this case, that it's appropriate for the trial judge to defer to that adoptive parent's judgment.
Thank you, counsel.
Thank you.
SJC-10641 Adam V. Adams.
Good morning, counsel.